Good afternoon, everybody, and welcome to the latest webinar from the education team in Mason, Hayes and Curran. Today's webinar is in conjunction with IPPN. My name is Ian O'Hurley, and I'm head of the education team in Mason, Hayes and Curran. And I'd like to start by introducing my colleagues on the webinar today. My colleagues Liam Reardon, Catherine Kelly, and David Ruddy, who will be known to many of you from his IPPN days, and Jack Durkin, who is IPPN Supports and Services Manager, and Jack is a former principal. So today's webinar we've titled, Have You Your Ducks in a Row? Essential Policies for Primary Schools. And so it's clear from that we're focusing today on school policies. That's really the focus. But we're not going to waste your time by kind of going through in a boring way the policies and the contents of the policies. You can read those yourself. What we try to do today maybe instead is to share some specific issues around the operation of these policies that are coming in our door in Mason, Hayes and Curran. And maybe in the course of that to highlight some of the, as we would call them, some of the pitfalls which you as principals, really should try to avoid. Now, I should say at the outset that if you've attended previous webinars of ours, I can't guarantee that you're not going to hear us repeat some advice maybe or some comment on a policy or a procedure that we've made in previous webinars. But like we have in excess of 800 principals registered to attend this webinar. So in that group, there's a sizable number of fairly new principals. And I make no apology, therefore, for maybe repeating something that could have come up on a previous webinar. Finally, just to say by way of comments that because there's 800 plus registrants today, we won't be able to use, as you can imagine, the chat function that is possible on these Zooms. David.
Thank you, Ian. And we're going to look at the backdrop there. You're going to, why have we got this particular topic? And most of you will say, well, policies are the bane of our lives. There's work involved in putting them together. And the question is then, why is it so necessary? So, Ian, you have seen the benefit of these policies in tough situations.
Thanks, David. Well, it's kind of the world in which we live, rightly or wrongly. Why are they necessary? And I suppose we would always say that, a lot of these policies that we're going to talk about today, grievance and complaints and disciplinary, whatever it is, they're in kind of an area of potential contention. And when you have potential contention, whether it's parents or staff member, you're into sometimes high emotion, and you need some sort of a structure or a roadmap, both you and whatever other parties you're dealing with. A phrase we often use is if you don't have a policy or a procedure, you're in the kind of Wild West, we call it jokingly, because there are no tram lines to guide you along. Just a little comment there. Board of Management sign-off is crucial for two reasons. One is because that may be queried, has the board of management. But secondly, you really want a situation where if your board has to deal with one of these policies at some stage, they're not seeing it for the first time. And just a last comment there on communication. Policies are not supposed to be sitting on your shelf gathering dust. You're supposed to communicate them, whether it's to parents, maybe the complaints procedure, sometimes even pupils, the code of behavior, staff members, grievance procedures, these sort of things. So communication is important.
Thanks, Ian. And I'm going to come back to you in a moment about those policies in more detail. But I'm going to call upon Jack Durkin. Of course, you all know as Manager of Supports and Services for IPPN and Principal Advice on that. So Jack, over to you.
Thank you, David. And as you say, I'm Supports and Services Manager here with IPPN. And we're a team of experienced school leaders available to IPPN members to provide professional guidance and help with queries. And we're delighted to partner with Mason Hayes and Kern today on this seminar to draw attention to this vital topic. You often hear that you can't run a school without goodwill, and everybody would agree with that. However, you can't run it on goodwill either. Effective and good schools, we say, are run on clear, transparent policies and procedures agreed by as wide a variety of the school community as possible. So whether it's the code of discipline, the anti-bullying, the leave policy, whatever, clear, transparent, regularly reviewed and signed off by the board policies should be in place. There are two things I always think when something comes. What procedure am I on here? What policy am I following here? Parental complaint, a grievance procedure, and what's the difference even between them? Is this competence or is it conduct? Is this someone who can't do the job, which is usually competence? Or is this someone who can do it but won't? And that tends to be heading towards conduct. And if a school finishes up in court or in front of some tribunal of some kind, God forbid, the determination will be made finally against their stated and published policy. And if that's clear, then the outcome tends to be better for everyone concerned. They're my initial thoughts, David, for now, but we'll be discussing in detail more stuff later on.
Thanks, Jack. And that's a fitting background to what we're going to do. So, Ian, you have put together a list of two sets of what we would call mandatory policies from a legal point of view. Schools will have other policies also to achieve good management on that. But can you take us through, first of all, the policies with a legal basis for pupils and then for staff?
Thanks, David. Yeah, well, as you said, schools, there'll be all sorts of policies. Some of them will be also coming from the department. But, you know, we're just looking at the ones that you actually are legally required to have, or if not, that you really must have. Obviously, you'll be familiar with Admissions Act, Child Safeguarding Children First. And we've put down in red there the kind of the legal basis for why you have to have all of these. So you can see those there for yourself. And that's on the pupil side. And then we've got a short little list coming up next for the ones on the staff side. You know, looking at particularly at bullying and harassment policy, they're sometimes called dignity policies. You know, they're incorporates kind of working together policies and procedures. Disciplinary, we're going to be dealing with these all again in a few minutes as we go down. Whistleblowing, protected disclosure is a very hot topic at the moment. Strictly speaking, the Act, the 2014 Whistleblowing Act, doesn't require private non-state bodies or public bodies to have a whistleblowing policy. But the law is kind of moving away from that, driven by EU regulation. So a time we believe is going to come pretty shortly where employers generally, and certainly big employers, are going to require to have a whistleblowing policy. We just have it in there because it's something that if it's not mandatory now, it'll be mandatory shortly. So just before I hand over to Catherine, as I'm going to do in a moment, I just want to say something about schools' admissions policy. So, you know, obviously every school has admissions policy, and you'll all be familiar with the fact that legislation came in 2018, which basically revolutionized both the process of admissions and also the content of admissions policies. So the content is 90-something% of the content of admissions policies is dictated by statute now. And the other thing just to say is that, you know, you'll all be familiar with the fact that you had to get your policy, your admissions policy, approved by your patron. But just a little reminder that if you amend the policy, if you amend it, you've got to get it approved by the patron as well. So some schools have forgotten about that, and we've just had to kind of remind them of that. But I'm going to hand over to my colleague Catherine Kelly now, because Catherine has been dealing with a particular issue which has ended up in litigation around admissions policy. Maybe you might explain, Catherine.
Yeah, it's in relation to separated parents. We've had a lot of cases which have been before the Workplace Relations Commission. So a separated parent would make a claim that it's usually the separated father has been discriminated on the grounds of gender because a child was enrolled without his consent in the school. So he will go before the Workplace Relations Commission and say that the enrollment of the child was discriminatory on the grounds of gender. And a number of awards have been made, small enough awards, 3,000, 4,000 euro of compensation. But we have appealed those cases on the grounds that we're saying, well, the school has to enroll this child unless there's a court order stating that the child shouldn't be enrolled. And that's very, very important. And luckily, the Circuit Court judge has agreed with us and stated that, you know, if the school doesn't enroll the child, it could have a Section 29 appeal, and it could possibly lose that Section 29 appeal because there's no valid reason to refuse to enroll the child. So basically, we have successfully appealed a few of those decisions. I have one coming up again soon, this week actually, and we're going to use the same arguments. It's not discrimination on the grounds of gender, and it would apply to a woman as well as a man. The school will enroll anyway. If a court order comes in place during that time, it will comply with that court order, but otherwise it's obliged to enroll.
So, Catherine, there's some reassurance there in relation to that Circuit Court case that you...
Yeah, absolutely, because every start of every school year, we get inundated with solicitors' letters stating you enrolled this child without the parents' consent and therefore this is discrimination. So it does give good guidance to schools on that point.
Thanks, Catherine, and I'm going to come back to you in a couple of moments now, because the next essential policy you'll need is the code of behaviour, of course. And the National Education Welfare Guidelines are the template to look at, and there's a statutory basis for them under Section 23 of the Education Welfare Act. And these are not really guidelines at all because, again, our education team find that the Section 29 committees and the courts will look at these in detail, and they're really the Bible or gospel. One of the things you have to just think of now is, and often we have queries to the office where the principal unfortunately may have to suspend a pupil. Does he or she actually have that power? Has it been delegated to them in writing by the Board of Management? Because under the guidelines, a principal can, with the delegated approval of the board, suspend up to 3 days and up to 5 days with the consent of the chairperson. So I think it's really important that if you don't have them in your present code of behaviour, you should have a discussion with the board about it, because otherwise, if you want to suspend for a day or 2 or 3 days, you'll have to have a full meeting of the board to do so. Another very recent issue that has come to our attention, very much so, and to Catherine and Liam Reardon and Ian, is the impact of Circular 2721. This is in relation to the reduced school day. And in a previous life as a principal, I very sparingly would have used this reduced school day as a means of supporting a student to try to get them back to a full day and using it as an alternative to suspension. What has happened now is the department, the circular, which is effective from January, states that the consent of the parents are required and TUSLA must be informed. So what we're finding is that a parent might have consented in the past and they've withdrawn that consent now. And the school is looking at really suspension as a remedy when they wouldn't have done so in the past. So I think that's a big pity. And we're seeing the worry and the angst of that coming across our desks, and we're trying to advise boards as best we can. Just to say that also in relation to your code of behaviour, the heading there does one size fit all, and that relates to the fact that your schools have now changed beyond all recognition in latter years. Many of you have opened special classes, and you're to be applauded for doing that. Schools are much more inclusive. But with the special classes, you have obviously children with complex special needs, exhibiting, some of whom, very challenging behavior indeed. So the code of behavior still applies to all students, even with special needs. But what will happen is there will be a forensic examination as to whether the school went over and above and beyond. And Catherine will be talking about this shortly in relation to a recent case she dealt with. So we're recommending that schools ought to, as an appendix to their code of behavior, to place and draft a behavior of concern policy. And Ian will be talking about maybe some of the few nuts and bolts that are involved in that policy. We would say that that will give you greater protection and it will complement your existing code. Recent poll by our team here last September in a webinar we had, is managing behavioral concerns an issue for your school? 75%. Now that was, I think, the first 2 weeks in September, and I would imagine it would be much higher. Do you feel confident in dealing with these behaviors? 2/3 of you said that participated no. And that is very disturbing. I'm not a bit surprised with the last piece. Do you have a policy? Because there's no statutory requirement at the moment to have one, but a lot of special schools or schools experiencing these behaviors do have a policy. This brings me now back to Catherine here to discuss the question of Section 29 appeals. And Catherine has been involved in a few high-profile cases that would have been reported widely in the media. So, Catherine, you might share, some takeaways on that from your experience, both with Section 29 appeal committees and in the High Court. Catherine.
Oh, thank you. There have been a number, a lot in the last few years, to be honest with you, and we're seeing an increasing amount of expulsions. It used to be that it was second level more so, but now primary level. I'm advising at the moment in relation to a first class student, pupil who is engaging in such disruptive behavior that they just can't keep them in the school. And in relation to the reduced day was actually working really well with him. But unfortunately, the parents are now not agreeing to that. And therefore, he's back for a full day and it's just causing him huge anxiety. So that's very, very important there. I think Jack might have something to say in relation to that later. In relation to the Section 29 appeal committees, they want to know that you've done everything possible so that you're not going the expulsion route. So you need to look for resources, you need to go to the CINO, you need to go to NEPS, you need to go everywhere to try and find anything you can do to keep this child in the school. So it'll be very, very important to have all of your paperwork in place because you have to look at it from every angle, okay? You also have to make sure that you comply with the newbie guidelines, which are not really guidelines. They are the Bible in relation to an expulsion. So you really, really need to make sure that you have all your ducks in a row on that and that you've complied in full and that you have gone, if NEPS, for example, give you a report, that you've gone down through every single recommendation that NEPS have made and you try and see if you can carry out those recommendations. And they may not be successful. Sometimes they are successful and you need to pull back from expulsion then, but they may not be successful and, the placement in the school may not be the appropriate one for that student. So the only alternative is expulsion and it's the last resort. So if you're not happy with what a Section 29 appeal decision has given the school, I would say that you should look and see if you can judicially review it on some basis. Maybe the appeals committee would have considered something that they shouldn't have under the law, and there might be a basis for appealing it on that basis. But we have done in the past judicially reviewed, difficult decisions made, and we were successful in those. And what happens then is it's sent back to another different Section 29 appeal committee, and you'd be fingers crossed hoping for a different outcome there.
Catherine, would it be true to say that you know where to pick your fights, as it were, with judicial reviews? Because
absolutely, yeah. You have to, we would have to take, get counsel's advice, a barrister's advice on it. What is the likely outcome of a judicial review? Do we have any kind of chance of success on this? And we would only go on that basis. You know, sometimes we look at a Section 29 appeal decision and we think, okay, well, I don't think there's any basis to challenge that. And, you know, the school will just maybe need to take the child back, see what they can do. And that doesn't mean that you can't go down the expulsion route again if things don't work out.
So, Catherine, you're going to look at a real life case that you were involved in and what the lengths the school had to go to successfully expel a pupil.
Well, this pupil was expelled. I mean, and this has happened on a few occasions on clients that I've had. Health and safety of the student, health and safety of other students in the school, health and safety of staff. You know, the child is so disruptive that it's having a huge impact on the school community, the whole school community. And the school had tried a series of interventions and exhausted all possibilities. And that's key there. They've exhausted all possibilities to try and change his behavior. So that was really the difference between, say, other cases and this case, in that we could show that the school had done everything possible, communicated with parents, communicated with NEPs, SNA support, everything it could possibly do, but it still couldn't stop that student from engaging in that kind of behavior and injuring people.
And then you got a very strong decision from the appeal committee, didn't you?
Yes, it was that he was a real and significant threat to his own personal safety, the school's staff safety, and the safety of the students. And this was in a special school setting as well. When you think of it, you know, that they would have had all the resources that were available. They would use all of those resources available, and they still couldn't keep everyone safe. And they also held that the school authorities have tried a comprehensive series of interventions, demonstrated that they've exhausted all possibility within the resources for mitigating the students' behaviours of concern at the school. You know, sometimes it comes down to, you know, looking at one student, whereas you have to look at the other students, the staff. How can you protect them? You have a duty of care towards them also. So you have to protect them.
Thanks, Catherine. And Jack, just in relation to Catherine mentioned the reduced school day. I know you want to say something about this yourself.
David, just to underline what Catherine has just been speaking about there on the reduced school day, it was unfairly somewhere presented as schools were using this widely to exclude students, pupils. The truth of it is that most schools were using it as a way of retaining the child in the school, and that should continue. And the default now is that the code of discipline kicks in. On the issue of the behaviour, that sometimes people tell us that they feel they have to put aside their code of discipline because this is a child with additional needs and so on. And of course, schools will do anything to keep that child in school. But I often say to people to think of the report as explaining the behaviour, but it mustn't be used to excuse the behaviour. So that's where you consider to have your code of discipline in one hand and the report in the other. And then a school will go to all the lengths Catherine has just described to retain that child in school, but it's not endless because other people have rights as well, the right of the teacher to teach and the other children to be in a safe environment, as well as the child's own personal safety. So that's using the report as I say, explaining it, but not excusing it. David?
Thanks very much for that. And that's been very helpful too. And moving on and continuing in relation to behaviours of concern, at the moment, schools are in the unenviable position that there are no department, there's no legislation, guidance or policy on handling behaviours of concern and in relation to physical intervention. The UK has guidance, but it's not statutory. And we have to go look at places like New Zealand if you really want to see good practice where there's legislation, a bit like our Children First, good department guidelines like the department have, in fairness, in relation to child protection, circulars and recommendations. So what we've done on the education team, we've distilled, and you've been listening to Catherine there, the learning we have from a lot of these cases and situations, and we see what works well. And we've also looked at international guidance. And Ian is basically going to now look and talk about physical intervention. Ian.
Yeah, thanks, David. The first thing I suppose is worth saying in this is that, you know, when we talk about physical intervention, certainly the public immediately think of, you know, a child being pinned down and that is, and international studies would best practice would very much dispute that. In other words, what they would see is that the approach to physical intervention is an incremental or a graduated approach, whereby you use the least serious or form of intervention that is possible in the circumstances. So we've just listed kind of 4 there, and this is picking up on international best practice. You know, that it may well be possible if a student is presenting with, threatening behavior, it may well be possible that, particularly towards maybe another student, another pupil, standing standing between the pupil and whoever the other person is or whatever. Again, maybe an octave up, leading, guiding, ushering, where the pupil retains, the maximum amount of independent mobility, if you like. An octave again up on that is holding a pupil's hand to retain a level of mobility. But, this is a situation where a pupil is about to throw something, maybe at another student, or even about to punch another student. It may be possible to just hold a pupil's hand. The final one is the one that we kind of try to avoid if possible, but it is sometimes necessary. And that's where you have to actually completely restrict mobility. And it often involves, in the extreme situations, 2 adults. But you really use that for the minimum force for the shortest amount of time. That's really the guidance. One of the things that we would really feel strongly about is that these sort of situations about physical intervention are situations which at some stage every school has to confront. And rehearsal among the staff is a hugely beneficial thing. In fact, I had a principal on to me who had a session with his staff some time ago, and some of the younger staff said they found it really, really helpful, because if they were out in the yard duty and suddenly they see 2 6th class boys dug into each other, losing their temper, there is best practice as to how you intervene in a situation like that. You don't just wade in the middle of it, or you might end up getting a clatter yourself. So, rehearsal is a huge thing.
And Ian, would you see this as important to incorporate in any behaviour of concern policy as an appendix to your code of behaviour, exactly that if there's physical intervention, this is what it involves, so that parents know about it and staff know about it?
Yeah, I would. And this is something even that could come up for conversation, at a parent-teacher meeting, or at a parents' council. Or a parents' association meeting, to understand that. In fact, actually, just on this, Liam has often commented, that one of the guiding factors in this is sort of a parental approach. Liam, you're on mute there for a second. Just maybe.
Sorry. Yeah. It seems to me that. That the test that would be used here by the courts, for example, would be the reasonable parent test, that that traditional test flowing from the idea that the teacher is, in that hackneyed old phrase, in loco parentis, but the test being what would a reasonable parent do in similar circumstances? Would they behave the same way as the teacher behaved? And so, when you're asking yourself what is reasonable, proportionate, and necessary, you can have in the back of your mind, is this what a reasonable parent would do in similar circumstances where they have to restrain a child for justifiable reasons? And that's where I was coming from on it, Ian.
Yeah. And thanks, Liam. And I think just as the slide there says, there's a well overused phrases, perhaps the reasonable, proportionate, and necessary, and they are important factors in this. and just, you know, the context in which a teacher might find himself or herself. The age of the student is obviously clearly relevant, because if you're dealing with a junior infant and you're dealing with a sixth class pupil, I mean, the form of intervention will be different, and supports, obviously the available supports. These are all relevant factors feeding into the reasonable, proportionate, necessary considerations.
And even going back to what Liam said, if a pupil runs out on a busy road, you know, you cannot stop to think, well, what should I do or not do? You're going to do what that reasonably careful parent will do and catch the child. It mightn't look good, but to save them from, you know, something more serious happening.
Yeah, I know, I agree entirely, David. The same way, just picking up Liam's point, if it was your own child about to run across a road, you know, you're not going to stand there and start debating the issue. You have to just grab the child, because you're preventing them from harm, and nobody is going to ought reasonably to criticize you for that.
Yeah. Thanks, Ian and Liam, for that. We're now going to move to a live poll, and we're asking you to participate in this, please. The idea of this is really to get a snapshot as to where you feel you're at the moment. It's anonymous, of course, and everybody will be at a different stage. So the first question there is, does your code of behavior need a review? And it's a simple yes or no. I think that'd be a fairly straightforward one for you, given where you are at the moment. The second question is in relation to your data protection policy, and Liam, immediately after this section, will be dealing with this. But is your staff familiar with the school's policy? We're obliged to have one. It's one of the other essential policies. Would they be conscious of the amount of personal data belonging to students and parents they have on their mobile phone? And if they lost the phone, would they know what to do or who to report to? So are they familiar with your school's data protection policy? Again, it's yes or no. If you can answer that, it would be great. Ian spoke earlier, and Catherine, about the admission policy. Just a question, most of you won't have, but have you amended or tweaked your policy since October 2020? Because some schools have, we know that, and they have come to us for advice in relation to that. So if you could answer that question, and we're coming then to the very last one there. When did you last review your safety statement? 1 year ago, 2 years ago, or 5 or more years ago? And again, it's more an audit of yourself, because it might then give you an indication at the end. We're going to recommend as a takeaway that you do a review of some of your policies, and this might inform you as to what needs most attention there. So Sinead Maher is with our events team. You cannot see her on camera, but she's hosting the event for us and this poll, and she's going to post the results in there in a moment. So the first one coming in, does your code of behavior need review? 63% say yes and 37% no. The second one there, the data protection, is your staff familiar with the policy? Splitting about half and half, 47-53. That's an interesting one there too. Have you amended or tweaked your admission policy since October 2020? Wow, well, I'm certainly surprised with this. 54% have. So going back to Ian's point there, if you have, has your patron approved of the amendment? So that's an immediate takeaway. Otherwise, the amendment isn't valid, but that's a big surprise to me. And the last one, when did you last review your safety statement? Very good figure there, 55% a year ago, and then breaking down 22% and 23% haven't done it in a long time. So there are the results of the poll there, and I'm going to look for a reaction. Jack, I'm putting you on the spot there, and any other member of the team who'd like to shout in. Is there any surprises in that for you? Or
a small surprise there with the first one, that 63% of people feel it needs a look at, but sometimes it's only that line about delegating to the principal is one. And it's no surprise number 4, where people, obviously because of COVID, will have been looking very frequently at their safety statement and such matters. That's my remarks there.
Yeah,
that's great then. Anyone else, or will we move on? Okay, we'll move on then. Thank you. Thanks, Sinead, for that. Liam, we're going to hand over to data protection there and yourself, and you might go through some of the basics. You need a policy, so why?
Thank you, David. Well, there's a statutory requirement to have a policy on this. Schools are data controllers for the purposes of the Data Protection Acts and under GDPR. And since the GDPR regulations came into effect, there's been an enormous increase in the number of data access requests made to schools and to employers generally. But particularly in relation to schools, our experience has been that in almost all cases where there is a data access request, be it from a member of staff or a parent in relation to a pupil or a parent in relation to themselves, there is always a context, and the context is invariably contentious. There is some issue going on, and as a way of progressing that issue or whatever, the person making the request thinks or perceives that they will gain some benefit by making the data access request. So I suppose the first thing I'd say is that always look at the context, and if it's coming in a context which is contentious in a wider way, you may decide to let your insurers know about it. In some cases, providing a person with what they have looked for, which is essentially their personal data, a copy of their personal data held on file, be it electronic computers or in hard copy in a school. Sometimes that's very straightforward. Other times, it's not so straightforward. Some schools have records going back years, and separating out the personal data from other people's personal data and from other information stored in the school can be difficult. And depending on the circumstances, your insurers may be prepared to assist you with that. That's been our experience. Just looking at the second point, what is redacted? And all you're entitled to is a copy of your personal data, the personal data that's held on file. You're not entitled to anything else. But the difficulty arises sometimes as to where the personal data ends, where it begins and when it ends. Because, for example, there could be a paragraph which is relating to a person. So it's not just always, the name of the person or whatever. There's often, there's information pertaining to the person which they're entitled to. So sometimes you will need assistance with that. So don't be shy about letting your insurers know if it is a complicated matter. If it's straightforward, so be it. But there is help available, and there has been a huge increase on this.
Liam, can I ask you about, and I hear the team discussing this regularly, the volume of material that comes in. Give us an example. How many pages could you be talking about in a worst case situation?
Like literally thousands. We recently just completed a data access request for a school where the teacher had sought a copy of his personal data, and the school had records going back over 25 years. Almost everything had been kept in the mistaken understanding that at some indeterminate point it might help the school in investigating the teacher. But it was there were literally thousands of pages which had to be viewed. That's one extreme. In lots of cases where it's parents, they're looking for records relating to their child for various reasons, and it's not so problematic. But there's always a context, almost always a context in which the request is made.
Right. Thanks for that, Liam. The next thing is you've done a list, you've trawled through what is coming in, and what are the top in relation to breaches?
Yeah. The most common breaches are inadvertent electronic disclosures. For example, probably the most common one is an email being sent to the wrong recipient. Somebody gets to see personal data relating to another person without that person's consent. I mean, in fact, I had one this morning where I received an email with an attachment to which I was not entitled from another firm. It wasn't within our firm, but another firm sent something to me that I was not entitled to. So that happens all the time. Another common mistake is the non-use of BCC when you're emailing and copying other parties in on it. Most schools have sophisticated software systems such as Aladdin, which store information in the cloud, and sometimes data can be accessed via a compromised cloud account. And then just simple loss of a laptop with a lot of sensitive information on it, loss of USB keys, phones, etc. Ian had a case some years ago where medical records, very sensitive medical records, were inadvertently copied to a parent body. So breaches can be very significant and very serious.
Liam, do you think there should be an open culture within a school that if a teacher loses their mobile phone in a nightclub, or a laptop is mistaken or stolen or lost, or that they should be able to tell the principal? They ought to.
Absolutely, David. Yes. Sometimes stuff happens, and it's not. It's how you deal with the problem. Problems will arise, but how you deal with it is how you will be assessed. And we've spoken before in previous webinars on crisis management when these things happen, or dealing with a data breach. There is a specific. There are steps you can take when there has been a data breach that will keep you on the straight and narrow. But that's a wide issue in itself.
Absolutely. And Liam, another thing, there was a traditional view: what we have, we hold.
Yeah.
But that's not so true, is it?
No, it's not, David. And this comes up all the time. We're asked this question very frequently. And the short answer is that a professional teacher's notes taken in the course of their professional duties as teachers form part of the school file. Now, it's different if you're at home in the comfort of your own house, writing up copious notes on David Ruddy or whatever it is, and you don't intend to show those notes to anybody else. Well, that's entirely private. But where you are taking notes in the course of your professional role as teacher or principal, or indeed as an SNA, they form part of the school file. Catherine has recently had a very interesting case in relation to SNA notes. Catherine, you might like to.
Yeah, it was in the context of there was an ongoing issue with SNAs in the school who were refusing to carry out catheterization in relation to a student, and the principal was involved, obviously, with trying to sort it out. She really was trying her best to engage with them, the union, and so that the child would, have his needs met in the school. And so there was a disciplinary procedure involved as well. In the middle of it all, the parent of the child made a subject access request looking for any personal data in relation to the child. But, during all of these meetings and everything, there were notebooks that the SNAs were using, and they were taking notes in relation to the principal's requests. And it was noticed by members of staff that they were taking in and out these notebooks out of their pockets and making these notes. So the principal had to inform them then that because as this request had been made, Technically, that contained personal data in relation to that child, and they had to hand over the notebooks, which didn't go down that well, but it was all part of what needed to be given to the parent involved.
I think, David, it's worth saying just that, and we often say this to schools, that, you know, principals, teachers, whatever, first of all, you must keep notes on certain matters. So, I mean, Catherine was talking a few minutes ago about, you know, if you have seriously challenging behavior, the importance of keeping records. You have to keep records, but you've got to keep them in a professional way, and, you know, on the presumption that they're going to be examined later. So write and throw away gratuitous comments like, you know, that pupil is behaving very badly, but sure, her mother's cracked. We've seen this stuff coming in. You know, that's a gratuitous comment, and, you know, that kind of taints what's in the record. So just to say that, you know.
Thanks for that, Liam, Ian, and Catherine. And Catherine, while I have you there, we want to go to the issue of parental complaints. And there has been an exponential rise in data access requests. I think Liam referred to that. Would you agree that there's a similar issue in relation to parental complaints, Catherine?
Yes, and the problem is that we get letters in from solicitors, you know, and it will be the first complaint that the school has received in relation to this matter. So, you know, it's a letter threatening legal proceedings if the school doesn't deal with this complaint. And the first thing we will do is we will write back to that solicitor and say, this is not an appropriate avenue for this complaint. There is a nationally agreed procedure that's in place to try and resolve issues between parents and the school, and that they're obliged to use that procedure first, and that they shouldn't be going to a solicitor before they have done that. Because we will refer them right back to the first stage of the procedure. Because obviously, if a parent is making an allegation against a teacher, the teacher is entitled to try and resolve that at the first stage, the informal part of the procedure, by sitting down with that parent and saying, well, let's try and sort this out. Then it'll go on to the principal. The chairperson of the board gets involved. You go all the way up through the different parts of the procedure. And then the chairperson will report to the board of management. The parents will be usually invited to come before the board of management again to try and resolve the issue. But if, say, for example, the board thinks that there might be merit in the complaint, I would advise that the board doesn't make a decision in relation to the complaint, because it should stop short of that and then go into the disciplinary procedures, because that teacher is entitled to fair procedures under the disciplinary procedures. And if the board has already made, you know, a finding that the complaint is upheld, well, then that teacher could say, well, you know, the matter has been prejudged and the board is biased against me because they've already made that finding. So I'd hold back. What we normally say is, you would say, this warrants further investigation under the procedures. The board is not making any decision in relation to this, and they put it into the disciplinary procedures before any decision is made. And that's the way to deal with that. But sometimes what happens is, you know, the parents come along to the meeting and the matter is resolved. And the parents like having a right of audience in front of the board. The best part about the procedure for us really is that it says that the decision of the board is final. So if the parent isn't happy at that stage and they go off and they try to take legal proceedings, or they go to the Ombudsman for Children, the school is covered usually by just saying, well, we went all the way through the stages of the procedure and we found that their complaint wasn't upheld and there was nothing further to be done.
Thanks for that, Catherine. And I think, Liam, you have said that you feel very strongly that parents should be given energy.
Yes, David. There's a provision at the start of stage 4 which says that when the complaint is referred to the board at stage 4, the board can decide of its own bat that the complaint has not been substantiated. And I've had numerous issues over the years, as I think have other members of the team. I think, Catherine, you have as well, of boards taking that decision without having met with the parents. And it then gives rise to a whole plethora of problems as to why did you not meet with us? On what basis did you decide that the complaint was hadn't been substantiated without meeting with us? And as Catherine said, that sense of getting a hearing is very important. So I think even though the procedures allow for that, I don't think it's a great idea for boards to make that decision without meeting with the parents.
Yeah, I agree. I think you should meet with the parents and try and resolve it as much as you possibly can, instead of just saying, no, we're not going to meet with them. I think that would be a bad idea.
Yeah.
Thank you. And then the Student and Parent Charter Bill is going before the Dáil at the moment, and there may be changes to the nationally agreed procedures, which have been agreed between the management bodies and the unions. So watch out for that space. A survey back in November 2020 by us at another webinar dealt with managing underperformance. And we won't go through it in much detail, but point number 4, I suppose, was the most stark of the survey, that only 15% of school leaders felt confident in managing underperformance. Jack, what would your reaction to that be?
Yes, David, it doesn't surprise me, because people will tell you that, the children are the easy bit. And then when you come to underperformance, that's a very difficult thing. And even the decision to do so and to go down that road, as we've talked about, it is very serious. But sometimes people ask about that, and they rightly might be thinking about activating a competence or conduct. But then you ask them, when did anyone ever speak to them about their behavior or their performance? And you find that they never did. And that's where the issues arise, when they jump in maybe too high on the ladder, the importance of de-escalating, someone speaking to them about it. But no, that doesn't surprise me, number 4, David, there.
Thanks for that, Jack. So Ian, I'm going to come back to you in relation to the basics and underperformance. I know there's a lot, we could spend a full webinar on this and have lost.
Yeah, no, we could, David, and just to echo what Jack has said there, you really, a principal should be kind of informally ticking people off if their performance is under par in a low-key way, and then it doesn't become such a big thing if somebody is spoken to rather than out of the blue. The first thing they're supposed to say is that there are 2 procedures, David: conduct and competency. They're both in the relevant circular letter. They're separate procedures. They're quite similar in some ways, but different in others. And one of the vital things to say is that, it's the principal who initiates everything in this. Competence, conduct. Nothing happens unless a principal is prepared to take up an issue. And that's not surprising, because the staff are accountable on a day-to-day basis on the ground to the principal. So it's the principal who has to be somebody who if you like, initiates something. And it can happen that there's a bit of each. There's a bit of competency, there's a bit of conduct in a particular problem. And we often say, it would be unfair on a teacher to run twin track simultaneous processes. That would be burdensome on a teacher. So we say, like, if it's a bit of both, use one of the procedures, and preferably the conduct one, but because the competency one, if you read it, you lose control of it towards the latter parts of it. It goes off to the chief inspector in the department, whereas the conduct one, it's possible to keep it within the school context. So, that's really, they're the things to look out for. Be aware, competence, conduct. Jack has spoken kind of what they might look like, and you have blind adherence to the procedure, because the unions will stick you to that blind adherence to the procedure.
And Dean, I thank you for that. And in relation to the competency issue, also the pdst have a role, and I know that Catherine and yourself and Liam have been impressed by the supports.
Yeah, Liam has had a couple of experiences that recently. Liam.
Right, yes, I had 2 cases of schools where the principal initiated competency procedures, which ultimately proved to be successful in in the departure of the two teachers. And in preparing the report to the Board of Management, both principals got great help from the PTSD, who were really supportive and very willing to get engaged. And it was something that I hadn't been aware of before that. And they were indicating their willingness to assist principals generally on this kind of an issue. So it's something to bear in mind. I think you did something as well. I think Catherine on it at some point as well. I think.
Yeah, I would definitely agree with that. I've had a few instances where they gave very excellent advice in relation to the competency procedures.
Yeah.
Okay, thanks for that. I'm conscious of time, but we do want to refer to bullying allegations and that. And so in relation to that,
well, David, if I just say a couple of words of that, just as much time permits. I mean, obviously, you know, if you're dealing with a bullying complaint, you've got to follow the procedure. Nothing radical in that. But you know, some principals feel bullied by members of staff, but you know, you would never, as a principal, use the bullying procedure against one of your staff members. So that, you know, if a staff member is, you know, behaving oppressively towards you, that's a conduct issue. That's a disciplinary issue, you know. And the other thing just to say is that, you know, whenever you're dealing with a bullying complaint, be it from a member of staff against another member of staff or a member of staff against the principal or whatever it is, there in all these procedures and in the teachers and SNAs ones, that there is provision for an informal resolution, whether that's mediation or some other arrangement. That should always be followed where possible, because if you get into an investigation, you're potentially going to have a winner and a loser. And that might be a resolution of the particular complaint, but it is certainly not going to repair relations. So just you know, where informal resolution is possible, grasp it.
Thanks for that, Ian. And just finally, managing underperformance. You have a few tips here. Any particular one that stands out?
Well, try to resolve early and informally. And the last, number 4 there, seeking advice. Now, there is advice available. We always say, seek advice, seek advice, seek advice. Don't do nothing. It's the default position often when we don't know what to do. Lawyers, solicitors, medics, everybody will say the same thing. Don't know what to do nothing. It's often the worst case scenario.
And the second last slide there is something that's very dear to Jack's heart, I know, in IPPN. But Ian, you thought it was important. You put it up yourself.
Well, and Jack may say a word on this as well, but we've just been struck by the fact that, you know, when a principal takes up an issue in relation to competence or conduct, it is not unusual in any way that there is kickback. That kickback can involve the staff member raising a grievance or claiming that they're being bullied, or they can go out sick, or they can send in a stress certificate, stress at work certificate, or combinations of all of these. And we say, you know, some principals come on to us very upset. You know, I've now been called a bully. And we try to say to them not to ignore the complaint, but to recognize that it's kind of, sorry to say, an occupational hazard. When you're a manager and you try to make somebody accountable who may not want to be accountable, you know, you can kind of expect the possibility of kickback. And it, you know, one of the things that we often say is, this, just because there's kickback doesn't mean that you go back in your box and you tear up your disciplinary or competency procedure. And Jack, you've have a couple of comments to make on that as well.
Just the same, that it is quite common for somebody to come back. But the best defense will be that you have followed the correct procedures yourself when dealing with that person. That is your best defense. And the other one, Ian, to finish with, as a chairperson of a board of management myself, boards have a duty of care to the principal also. It's very easy to say, take care of yourself, but they often say, who do I have to go to? And sometimes boards and chairpersons might need reminding of that fact. You don't have to go crying to them, but maybe remind them that you also have a set of rights as well that aren't always taken care of.
Thanks for that, Jack. So just like we always try to pride ourselves on finishing within the hour, and I think we're about 30 seconds away. So just to say before we finish up, I hope you found this webinar helpful. We tried to be a support to principals. We've said previously, don't just beware, don't do nothing. If you don't know what to do, ask for advice, other principals, IPPN, your management body, ourselves, whatever it is. And just one last thing, you'll automatically get a feedback link from our office at the end of this webinar. And if you could take a couple of minutes to fill it in, some of you will be familiar with it because it really helps us, whether it's positive or negative feedback, it really helps us because it helps us with future webinars and keeps us on our toes. So try to fill that out if you can. Otherwise, on behalf of us all, I'd like to say thank you sincerely to you for tuning in to this webinar, and good luck.